You're contemplating putting together an LLC operating agreement, or maybe you already have one. Well, in this video, I'm going to break down what can happen when you don't set it up the right way. And I'm going to show you the problems that arise with having, as I refer to it, as a junk operating agreement. All right, let's get started. Okay, so the purpose of having an LLC is asset protection, number one, and also to protect you in case you're audited. And so you want to make sure your operating agreement is as strong as can be if you're ever involved in a lawsuit, because people are going to challenge you based upon that operating agreement, and they're going to work darn hard to try to pierce the veil of your LLC. And this is why when it comes to drafting LLC operating agreements, it's never a one-size-fits-all. Number two, make sure you're using a company that understands how to set these things up, and they just don't throw you a form document and charge you a lot of money for it and masquerade as if you have something really valuable. Because I can guarantee you, the first time you're challenged by a reputable firm, they will sink their teeth into what you created and find ways to tear it apart. What I'm going to do in this video is I'm going to break down for you a recent client who shared with us a copy of their LLC operating agreement that was prepared by a company out of Nevada. I refer to them typically as an entity mill. They turn out a lot of Nevada and Wyoming entities, and it just goes to show you what can happen or what the problems are when you rely upon someone to put together an operating agreement that's not in your best interest. Okay, so let me just show you what I realized when I started going through this operating agreement. Now, I could tell right away that this operating agreement was most likely a form document, meaning that it was pre-printed, possibly in an out-of-state printing room, and they just bind it up and send it out to the client. All they do is customize a few letters in there, names in there, to make it appear as if they spent some effort doing it. How do I know this? Well, one thing is you can always, as a dead giveaway, is when they always capitalize the names, all right? So always the names are capitalized, and typically they do them in bold. That is, for me, a red flag that you're dealing with a operating agreement that is just a form document where they've only replaced one or two fields and they're masquerading as if it's customized. You can also see here the font is a completely different size in this operating agreement just on that one line. So again, these things are just printed out. And I know this because this individual client that we're working with provided us with another operating agreement that was drafted for a different state, Wyoming, and it looked exactly like the Nevada agreement. Now, obviously, you'd expect them to be different. And if they don't have any specific language in there that makes it appear that they're changing it, then you know that it's still a form. But those are just minor things, all right? Let's get down to the meat of this operating agreement. So when I reviewed it, the first thing that I came across that is a huge mistake and red flag for anyone creating an LLC is your business purpose clause. You see, the business purpose clause of your LLC defines what your company is entitled to engage in, what type of activity. Now, a lot of companies that produce form LLCs will not be very specific here. They'll just typically use the words all lawful business activity, stating that this company can engage in all lawful business activity, so it just leaves the door wide open. Now, to me, that again is another red flag that I'm looking at a form document. I'd like to specify, what the company is entitled to engage in. If it's investing in real estate, then build out a clause around real estate investing. If it's flipping, then have a different clause for flipping. Because these business clauses are going to be important if you're working with lenders or third parties or reviewing your operating agreement. They want to know that you created a company with a particular business purpose in mind. And I just didn't set up an LLC and then try to figure out what I'm going to do with it. So it just shows, your intent. It's like having a business plan that you've put some thought and effort into it. What's problematic about this business clause is it doesn't even say what the company can do, that it can engage in any lawful business activity. In fact, it takes actually the contrary approach. It states here that the company shall not engage in insurance, brokerage of securities, or business of any profession limited by the Nevada statutes, or has to be licensed individual without the pertinent approval from the licensing authority. Okay, well, good. You told me what I can't do, but what can this business do? Now, if I was coming after this company, This right here is what I would use to take it down. If this company went out there and engaged in real estate investing, or if it was running a Turo business, it was running an Uber driver, whatever it is, you're not authorized to do it. Your company does not say you can do any business activity. It just tells you what you can't do, but it doesn't tell you what you can do. Now, somebody could say, well, Clint, by negative implication, you can do anything. Okay, so now what you're asking the court to do is just make stuff up for your operating agreement because you didn't put it in there. Well, it wasn't you. You didn't know this. You relied upon someone else to do it, and obviously they failed. So that is a big red flag. When I saw this right away, I told the individual, we reached out to the client, said, hey, this thing's got to go. All right, you need to specify its business purpose. Now, this one actually happened to be set up for real estate, and that's important because as we go into this document, we talk about other aspects of an LLC. It's all going to play together because if you're dealing with lenders, you're dealing with title companies, you're trying to sell the property, you're going to have to specify why you set it up and what powers we have and control to do this. Okay, so the next major error, payments to members, okay? All right, so except as provided in this agreement, no member, person, or entity controlled by a member is entitled to remuneration for services. Now that's a problem, and I'll tell you why. Because many times when you set up a structure, maybe you're going to bring on a management entity that you control, and you want to pay that management entity a fee for serving in that position to lower your income taxes. You know, get them off the LLC, push income up into a corporation where you're going to get more deductions. Let's say you do all that because you've watched one of my other videos about the benefits of having a management entity and you've got this operating agreement and you're like, oh, I'm going to set up an LLC and manage it. And you start doing all of that. If you get audited, the IRS pulls this operating agreement, they're going to point to this clause and unwind all those payments and say those were not legitimate deductions because you were not authorized to make them because your operating agreement prohibited you from doing this. It astounded me that this would actually be in there. It's crazy. Why would you say you cannot pay a manager? All right, you should put in there that they have the option to do it. Okay, they're not required to, but they may. Simple as that. But to use language that you shall not makes zero sense because you then take away flexibility for that company to do certain things. So that was another big red flag for me. Okay, so the third one I came up with here is the management powers. Now let's say this LLC was intended to own a brokerage account. If you wanted to be a trader, I can tell you right now that if you send in this operating agreement to a Charles Schwab or some other broker that you're trying to work with and they looked at this operating agreement, you're not getting a brokerage account opened up. You take that business purpose clause and then you look at the management powers, which states that the manager has all the control over the company. Doesn't happen. You have to actually spell out the control that the manager will have over this limited liability company. And if you're trading, you better get into the details. You can trade options, you can do Forex, you can do crypto. If that's not there, you don't get it. Because they do scrutinize these operating agreements. I've opened up many LLCs for myself for various businesses, trading businesses as well, where I trade. And I always get scrutinized. They always look at the operating agreement. And so you have to have that language built into it. So that is a huge problem. But even more so, where the conflicts start to arise and which will create problems for the individual if they went forward and used this to conduct business. It states the manager shall have the full and complete and exclusive authority, power, and direction to manage and control the day-to-day business holdings and affairs of the company. So essentially what they're saying here is that it's set up as a manager-managed LLC, right? It doesn't define who the manager is. I guess we're supposed to glean that somehow, some way, but it's a manager-managed LLC, so you would expect us to at least state who the manager is. But it doesn't. Because to do so would require the person who created the company that set these things up to actually ask the individual, who do you want to manage your limited liability company? If you did that, then you cannot create the form agreements and just pump these things out to people, right? So it doesn't ask for who the managers are. So we're going to go on past that. Now you get down here to another requirement. annual meetings. Annual meetings of the members are required to be held. Why? Why would you specify I have to hold an annual meeting? Because if I forget, then I've violated my operating agreement. So this is another one of those requirements that is nonsensical to me. As a drafter of operating agreements for doing this for 27 years, you do not put this type of language in there. What you would put in there is the members may agree to have an annual meeting, but you don't require an annual meeting of the members. It just, I set up an LLC for myself. Why do I have to have a meeting with myself on an annual basis? Then I have to document that. And if I miss it and somebody sues me, they'll say, hey, you haven't respected your operating agreement. Therefore, your operating agreement's not going to respect you and it's not going to protect you. You're being set up for failure with this type of operating agreement. So people operate under the false assumption that by setting up that LLC, and if it's involved in a lawsuit, hey, I'm protected from the liabilities associated with my company. If I was the attorney on the other side, I'm chewing this thing up and then I'm coming after you because I'm finding these simple little errors that I know you're not going to abide by. Most people don't even read their operating agreements. And you have to draft an operating agreement with that in mind, that your client will probably not read the entire thing at the level of detail that they should. So you have to be aware of that and make sure that you're protecting them with the language you put into there, okay, by not having requirements. All right, so the next area I came up with in this operating agreement that is a particular concern, distributions of assets. So the members decide when there are going to be distributions, not the manager. Now, if it's a manager-managed LLC, the manager should be making those decisions if there's going to be distributions for the members. And in fact, that's how you should do it to begin with if it's manager-managed. Because by setting up a manager-managed LLC, you're implying that you're going to have possibly more than one member at some point in time. So why do you want to be tied to this member that you may get crosswise with that decides, no, we're not making any distributions. And now you're stuck and you can't take money out, right? Because that's what can happen. If you decide to gift membership interest to a child because you want to start reducing the value of your estate, or you want to bring them in and have them understand what real estate investing or running a business is like, and now they're a member, but now they have control over whether or not you receive money on an annual basis because it goes to a vote of the members. Some people could say, well, we expect that they're going to want the money, but maybe not. Maybe they know you need the money more than them and they're going to use it to their advantage to get some concessions. So these are this type of language here, again, it doesn't make sense. This should be with the manager and never with the members. It's as if they tried to draft a manager-managed LLC off a member-managed LLC and they didn't do a good or they did not scrutinize this operating agreement enough to find the inconsistencies that are bound within here. All right. The next item that we come across here, bank accounts. Now, what have I been talking about? Manager-managed LLC. So if it's a manager-managed LLC, then they're required to conduct all the business affairs of the company. Then why are all the checks only being signed by members? So are the members the managers, or is a manager the managers of this LLC? I don't know any longer. Can you imagine the problem you're going to have there? Hey, I'm managing a limited liability company, but I can't sign the check as a manager. I have to get a member to sign the checks of the company, or only the members can make deposits. Go down to a bank, try to open an account with this LLC, and specify that you or your entity that's a manager is the one opening the account and has signatory authority. Will never happen. The only persons that have signatory authority are the members of the company when it comes to signing checks. But they don't run the business, they just sign the checks. Again, you're creating problems. And each time you set up a clause like this in an operating agreement that changes the normal course of operating a business, which you'll probably never abide by because you'll get a bank to open an account for you and you'll start signing checks and acting as the manager of your LLC. And then you get sued and then you get zinged because you were writing checks and you were obligating the company and you lack the authority to do it. That's what they're setting up here. The other thing that I came up here with there that really, really bothers me is when I see an operating agreement like this. Hey guys, You fill in the rest, figure out who you want the members to be for the company. And oh, by the way, where's the manager? Again, the manager is missing. If you have a manager-managed LLC like this entity stated it was, you should have a manager signing the agreement. Now, what I pointed out in this simple 10-page operating agreement were some of the most glaring errors. What I did not point out to you are some crucial provisions that are missing, that aren't even in here, namely charging order protections. I mean, one of the reasons why we set up LLCs in Nevada and Wyoming is because we want to be protected in the event someone sues me personally and they go to seek a charging order against my interest in an LLC, and I don't want to have to distribute them money. But where does it state it in this operating agreement? Well, I went through it kind of quick, but I can tell you I couldn't find it. Okay, it's not in there. Or how about this? Revenue Ruling 77-137, that if you put a charging order on my interest, I'm going to allocate my taxes to you. You're allowed to do that under the Internal Revenue Code, under that revenue ruling, but not under this operating agreement. And that is a huge deterrent to keep creditors away. Transfer restrictions, they're in here, but they don't have the necessary provisions in here that you would want in a typical operating agreement to prevent someone from taking control of your LLC, because you gave the power to the members over crucial decisions. And if you got sued and somebody were to take this LLC interest over, you give them the control. This is why, if you're going to go to the trouble of setting up an LLC to protect your assets, which I advocate, then make sure you're setting it up correctly, or it will be a waste of your time. And in fact, you could be putting yourself in a worse position by having an agreement that works against you, as this one does, versus one that works for you. This is what we do here at Anderson, and we'd be happy to help you set up your LLC operating agreement. If you go into the show notes, I've got a link for a free strategy session. You can sit down with one of our strategists here at Anderson. We can talk about your structure, make the proper determination as to the right type of LLC that you need for your investing, for your business. Because as I stated earlier, it's not a one-size-fits-all. If you're trading, that's a different operating agreement than if you're investing in real estate. You also want to make sure the tax provisions match. This one was clearly not set up the right way from a tax perspective. It was set up as a partnership, although it was supposed to be a disregarded entity. I mean, these are all the things that come up later on when you're challenged. And I always tell people, hey, it all works until you're involved in an audit or until you're involved in a lawsuit. That's when you're going to find out what you have. And you don't want to wait until that point. You want to know ahead of time. So, hey, if you're at that point, you're ready to move forward and get something created for yourself, go into the show notes, click on the link for a free strategy session, and we can walk you through how to set up the right structure for your activity. Take care.